Hello and welcome to Point One. 6 minutes of ethics opinion today could keep the legal malpractice claims away. Of course, no guarantees. Today we're going to talk about New York State Bar Association Ethics Opinion 1060 that covers rules 1.15b, c, d, and e, and rule 5.3. The question, this is a long one as opinions go. The question today is, may a law firm ethically authorize a non-lawyer staff member to direct its bank to open individual sub-accounts for the master lawyer escrow account maintained by the firm? And may the firm ethically instruct the non-lawyer staff member to direct the bank to transfer funds from the sub-account to the master account? It's a bit nuanced, it's a bit technical, but, the conclusion is yes, a lawyer can do that. But there's kind of a stricter standard than normal. Obviously, attorneys are always responsible for supervising non-attorney staff and even attorney staff to some extent. But here, the ethics opinion finds that the law firm needs to exercise close supervision. So it's a little more than supervision over the non-lawyer. And withdrawals from the master escrow account can only be authorized by a lawyer admitted in New York State. So, the rule allows the non-lawyer to use the sub-accounts, but at the end of the day, the lawyer retains professional responsibility for the non-lawyer's conduct. The facts are long. The law firm wants to have the non-lawyer open the account and sort of manage the accounts, these sub-accounts. And I have to plug a recent article I wrote about the role of paralegals in law firms, called Paralegals, the Law Firm's Achilles Heel, and I cleverly put the heel in parentheses to demonstrate that, my opinion is paralegals are the Achilles, the invincible heroes of law firms, but at the same time present a real weakness. The more and more attorneys rely on paralegals, the greater the risk there. That was published on LinkedIn April 6th, just a couple days ago. So the firm would permit distributions from the master account to be initiated only by the lawyer, but the non-attorney staff, the paralegals and such, would be able to transfer funds from the sub-account. The only way to get the funds out of the master account would be with a signature from a lawyer admitted in New York. And the non-lawyers would have no authority over the master account funds. So here it's really limited. The firm wants to have sub-accounts, likely for each client, and then, be able to let the non-attorney staff move the money around out of those sub-accounts into the master account. So the opinion goes to Rule 1.15e, the requirements for authorized signatures on attorney special accounts, and goes through the laundry list of rules related to attorney accounts and ensuring that there's no misappropriation of funds, maintaining the funds in special bank accounts, maintaining records, and ensuring that withdrawals are only done to a named payee, not to cash, are made by check. And that the attorneys authorized to withdraw the funds are admitted in the state of New York. Rule 5.3a provides a law firm shall ensure that non-lawyers who work for the firm are adequately supervised. And again, the opinion here kind of bumps that requirement up to this close supervision standard. 5.3a continues that the degree of supervision required is that which is reasonable under the circumstances, taking into account various factors, particularly the experience and training of the person whose work is being supervised. So the reasonable circumstances under 1.15 seem to be bumped up to a higher standard of care in this instance. 1.15a states that a lawyer in possession of funds belonging to another person is a fiduciary to that person. And the comment to Rule 1.15 explains that the lawyer should hold such funds using the care required of a professional fiduciary. So it's an interesting split here in that it pushes it beyond the scope of just a legal malpractice claim, although certainly a legal malpractice claim could still be viable, to a breach of fiduciary duty action as well. So, of course, there's insurance considerations there that you'd want to think about. The opinion notes that in Opinion 693, the responsibility for clients' funds may be delegated, but the lawyer remains ultimately responsible for the client to any errors. Comment 2 to Rule 5.3 notes that a law firm must ensure that non-lawyer assistants are given appropriate instructions and that the firm should make reasonable efforts to establish internal policies and procedures to protect the clients. So aside from simply designating a closely supervised employee, the firm needs to make sure that there's some sort of internal policy and procedure they can look to. The opinion cites to the matter of Galasso, 19 New York 3rd, 688 from 2012, which involved a disciplinary proceeding against an attorney who failed to properly supervise a bookkeeper, resulting in just a terrible mess. And the opinion goes into quite a bit of detail about that case. The big takeaway here, I think, is that while this is something that the New York State Bar Association believes could be delegated to a non-attorney, it's a real risk. And I think there has to be a balance conducted, a pros and cons analysis here of whether it really is worth delegating this duty to a non-lawyer or even to another lawyer. And, again, the reliance on paralegals, assistants is completely understandable, and it's a growing trend in the profession. But it's one that does come with risk. It's a double-edged sword. And, there's some other interesting ideas here in the age of COVID, e-signing, and how using the stamp, the opinion goes back to how assistants can use a stamped signature of an attorney. But again, the lawyer remains ultimately responsible. So it's interesting to think how that will be employed in dealing with, COVID and sort of our new normal with electronic signatures and such. So